All right, so just for everyone in the gallery to be aware, this is a case between the LSCS and also with Mr. What was his name again? I'm sorry.
Junior Bucks.
Junior
Mr.
Bucks.
Bucks.
Mr. Bucks. Thank you. Thank you. Um, shall the shall the plaintiffs begin with their opening statements?
Okay. So we are here today to make sure that my client, Mr. Bucks, gets what he deserves. We feel that he was wrongfully identified, as well as there was a lot of tension between himself and the arresting officer that we felt was unnecessary, and we want to make sure that my client, Mr. Bucks, the gets what he deserves for the false imprisonment and the pain and suffering that he had to endure and that he is currently enduring today.
Also racial profile.
And we also want to make sure that there were some words that were said that we find as racial profiling. We want to make sure that the arresting officer does get that he gets reprimanded for what happened. We don't want him to get off scot free, and we want to make sure that no other citizens in Los Santos get the same treatment from him or any police officer.
Is that all, Mr. Davis?
Yes, that is.
All right. Thank you. Mr. Mason, do you have an opening statement?
I do, Your Honor. May I approach?
Yes, you may.
Your Honor, I represent the Los Santos County Sheriff's Office in this matter. Officers of the Los Santos County Sheriff's Office uphold themselves to the highest tradition of excellence. And I believe in this matter, the evidence and the testimony that we are about to hear and be shown today will not only prove that my defendant, my client, was reasonable in his use of force, but also it was necessary. And I personally believe that tensions are not a factor in this incident. This is a Fourth Amendment tort regarding unnecessary use of force or detainment. And I believe the evidence and testimony shows that our defense counsel and our team was justified in that use of force, Your Honor. So that concludes my statement.
Thank you, Mr. Mason.
Yes, Your Honor.
All right, since the opening statements have been heard, we can quickly move on to any presentation of any evidence that both parties may have. Mr. Davis, do you have anything that you'd like to present to the court at this time?
I do. There is body cam footage that my client has that that states and shows that he was wrongfully treated.
Okay, and I did see that within the docket, and I did kind of skim over it, but can you please describe to the court what is in that video?
So my client, Mr. Buck, is. Oh, sorry, Your Honor.
No, you're fine.
My client, Mr. Bucks, he was leaving the gas station and he was going to Mount Zona to get treatment. And when he arrived, there was already a sheriff's vehicles there. Once he went back to surgery to get treated, he came back out and there was an officer who came in through the door and was following him out. Um, he was telling my client, "Hey, stop, stop." Actually, he said, hold on there, partner. Sir in the vest, I'm going to need you to hold up there, my man." And then my client continued walking because the officer did not identify himself as a police officer. Um, so my client continued
Officer
walking, and
didn't
then
tell me I was being detained or nothing.
Mr.
and then he
Bucks?
also he
Shh.
also then tased him. Um, and he stated that after he tased him, he stated that he had been following Mr. Buck from the gas station. But how could that be the case when his vehicle was already there at the hospital? And then after he had detained Mr. Bucks, he then was, I guess he was on the radio, and he had referred to my client as a skinhead. And we find that very much so as racial profiling. And then they continued to have a little bit of a heated conversation back and forth because the tension was tight. And then finally, Mr. Buck, I mean, they did end up releasing Mr. Bucks.
Okay. And is that everything
Yes,
that
Your Honor.
happened? Okay. Do you have anything else to present at this time? Any?
No, ma'am. Not
Do
at
you
this time.
do you have any witnesses that you'd like to call to the stand?
Does anybody have something to drink? I'm about to pass out.
I do not have any, not at this time.
Okay. Thank you, Mr. Davis.
Thank you.
Mr. Mason, do you have anything that you'd like to present to the court at this time?
Sir.
May I approach, Your Honor?
Yes.
Your Honor, at this time, the Sheriff's Office does not wish to present any additional evidence that's not already been posted on the docket. We feel that the plaintiff's body cam footage is sufficient to articulate our side of the events. With the court's indulgence, we do plan to call one witness, and we are prepared to do so whenever the court is ready to receive that witness.
I'm ready right now if you are.
Okay, beg the court's indulgence. Can you give me 1 moment, please?
Yes, of course.
All right, stand by, please.
Do what?
Mr. Bucks, has your thirst been quenched yet, or are you still thirsty?
No, ma'am, I'm good. Thank you very much.
You're welcome.
Yeah, I'm not gonna lie, I'm kind of thirsty over here too.
Your Honor, my client, Major Jason Gatsby with the Los Santos County Sheriff's Office, has invoked his right to plead the Fifth Amendment of the United States Constitution. Therefore, I will not be calling him as a witness. I do, however, call the Sheriff of Los Santos County, Garrett Oakley, to the stand.
All right. Please sit to my left. And bailiff, swear him in, please.
So you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, you may be seated.
Thank you.
Your Honor, may I proceed?
Yes.
Thank you, Your Honor. Sheriff Oakley, how are you today?
I'm good. And you, sir?
I'm doing well. Sheriff,
Is everything okay back there? All right. You,
Your Honor,
you,
we're ready to continue. if you
yes,
are.
you may proceed.
Sheriff Oakley, first of all, just some foundational issues. Are you able to, first of all, are you shouting, sir?
I am.
Okay. And Your Honor, I would ask if the court can verify if the members of the gallery and the plaintiff's team can hear the sheriff.
Are you able
Yes,
to?
we can.
You
Yes,
can.
we can.
Everyone back there, even people sitting as far as they are, can you hear? Good. All right.
Sheriff, can you please can you state your first and last name to the court and spell your last name, please?
Sure. First name is Garrett, Garrett. Last name Oakley, Oakley.
Thank you, sir. And what is your current position?
I'm currently the sheriff of Los Santos County.
How long have you been in this position?
2.5 weeks.
How long have you been a law enforcement officer?
In the state of San Andreas, I've been a law enforcement officer for 7 years. I've also been a law enforcement officer and outside of the state of San Andreas in Texas for 10 years.
Are you familiar with the defendant, Major Jason Gatsby?
I am.
Can you explain to the court what Major Gatsby's role is in the sheriff's office?
Yes, the major is, with technicalities in mind, the third in command of the Sheriff's Office, and is a absolutely vital member of my command staff. Major Gatsby oversees all of the fleet management aspects of the Sheriff's Office, and is also one of the first line supervisors on our patrol division. Basically, meaning that anytime a suspect or anybody that we're dealing with requests a supervisor, Gatsby is usually going to be the first one on scene that's going to handle any type of those complaints or concerns.
And Sheriff, in your position of Sheriff of Los Santos County, are you an elected official
I am appointed.
appointed by the governor?
Correct.
Okay. Can you outline your training experience, which academy you have been to within San Andreas or in the state of Texas, as you have referenced?
Sure. I first started my career in San Andreas in another city. I was a member of the San Andreas State Police and completed their training academy. That was in late 2016, if I recollect accurately. In Texas, I went through the academy in 2011 with the Lubbock Police Department. And I also currently serve as a certified field training officer and a master peace officer in the state of Texas, according to my Texas Commission on Law Enforcement license.
Thank you, Sheriff. And in all matters associated with this case, would it be fair to say that you are the most qualified representative to speak and testify on behalf of the Sheriff's Office as the presiding sheriff? Would that be correct to say?
Correct. And my master peace officer certification awarded to me by the state of Texas also qualifies me as a use of force expert and trainer, instructor.
Thank you, Sheriff.
Hold on. We got
Sheriff, are you familiar with the United States Supreme Court and more specifically U.S. Supreme Court case law?
I am.
Can you explain to me your knowledge of the Supreme Court case law titled Terry versus Ohio?
Yes. So Terry versus Ohio, in layman's terms, establishes what law enforcement commonly refer to as stop and frisk, meaning that when dealing with a suspect, if a police officer has reasonable suspicion that that suspect may be armed, then they are allowed to stop that individual and pat them down on the exterior of their clothing in the interest of checking that individual for weapons. As that relates to the Fourth Amendment, when it comes to search and seizure and expectation of privacy, as well as intrusion, it does not give a police officer legal authority to reach within that person's pockets or to search inside of their personal belongings, but it does legally give a police officer the authority to pat them down and essentially check their pockets from the outside for weapons.
Would it be fair to say that Terry v. Ohio governs a lot of a police officer's actions as regards to reasonable suspicion that criminal activity is afoot?
Yes, and I would go so far as to say that Terry versus Ohio applies to my job on the daily, both within the state of San Andreas as well as my outside experience in Texas. It's a daily occurrence.
Thank you, Sheriff. Are you familiar with the United States Supreme Court case law titled Graham versus Connor?
I am.
Can you explain that to the court, please?
Yes. Graham versus Connor is commonly one of the first U.S. Supreme Court case laws that is taught to police officers and certified police academies. Graham versus Connor is a Supreme Court case that was established to give courts within the United States of America a point of reference to use when they are determining whether or not a use of force incident involving a police officer is reasonable. It establishes a term that is known as objective reasonableness, which basically states that any use of force incidents against the police are to be investigated from the officer's point of view. And while there's a long list of factors that go into making a determination, the most important ones are what the officer knows at the time, the facts that are available to him, and what the officer sees in front of him at the time. And using those important factors along with the other more minor factors in what is a very, very long list. It helps courts make reasonable determinations on whether or not a use of force incident by a police officer is reasonable and not excessive.
And these case laws, this is all information that you have not only learned in your academy days, but this is also Supreme Court case laws that you have also included in your standard operating procedures. Is that fair to say?
Correct. It is also a part of our training program, and we do not let our personnel graduate our training program until they not only have learned the information, but have proved proficiency in that information to us.
Thank you, Sheriff. And we'll get to the training program here in just a few moments. Regarding your testimony versus Graham versus Connor, would it be reasonable to say that with Graham versus Connor, an officer is not judged based off of 2020 hindsight, but rather the facts and circumstances that the officer is presented with during that moment in time, correct?
Yes, that is correct.
Thank you, Sheriff. Sheriff, what is your knowledge of the term qualified immunity, and can you share that with the court, please? Or, one moment, strike that. Sheriff, first of all, are you familiar with the term qualified immunity?
I am.
And can you please explain to the court what your knowledge of the term qualified immunity is?
Yes, qualified immunity is essentially a doctrine that provides certain legal immunities and protections to certain state as well as federal government employees, which includes law enforcement. The basics of that doctrine state that a police officer cannot be held personally liable in any cases where no one's constitutional rights have been violated.
Okay. Sheriff, are you aware of the facts regarding the use of force incident occurring at Mount Zona Hospital involving Major Gatsby, as the plaintiffs have provided evidence relating to body cam in this matter? Are you familiar with that incident?
I am. I have been briefed on that incident in detail, and I have viewed the body cam footage from Major Gatsby's perspective.
Can you provide an overview of your recollection of the facts as it relates to the incident involving Major Gatsby? Excuse me.
I can. Your Honor, if you wouldn't mind, if I could have 30 seconds just to grab a drink of water. I'm a little bit under the weather, and I'm having a little bit of difficulty speaking as a result.
Yeah, of course. Of course. Where's my... I dropped my pencil and I can't find it. Oh.
Bucks,
Okay,
you okay?
thank you. So,
One moment, Sheriff.
sorry.
Mr. Davis, are you okay, sir?
Yeah, we're good. We're good.
Okay. Beg the court's indulgence, Your Honor.
No, you're fine. I was
Sheriff?
curious too if they were okay.
Yeah. Sheriff, please tell us about
Where the
your knowledge of the
frick?
incidents regarding Major Gatsby and Mountain Zona Hospital.
Sure. So on December 31st of 2023 at approximately 2100 hours Eastern Time, the Los Santos County Sheriff's Office responded to what turned out to be an extensive shooting that took place at the quarry that is just east of Sandy Shores and Grapeseed. It's actually right across the highway from the 24/7 convenience store and gas station that sits on the in the southbound lanes of Los Santos Freeway. When law enforcement arrived on scene, there were multiple involved individuals. A lot of those individuals were wearing vests, or what are commonly known as cuts, commonly worn by members of motorcycle clubs. Multiple subjects who were already in police custody had to be transported to the hospital by local EMS staff because the on-duty available EMS that we had available to us at the time did not have the capacity or the vehicles to transport all of the downed individuals that were injured as a result of this incident. As a result, Deputy Chief Mason with the Los Santos County Sheriff's Office ordered Major Gatsby to follow a local ambulance to the hospital that contained one of the subjects that was involved in the shooting, who was at that time in custody. Major Gatsby followed the ambulance to the hospital, where the ambulance and the subject within the ambulance disappeared as it arrived at Mount Zona Medical Center. Major Gatsby parked his vehicle and he entered the hospital and found a subject who he believed was one of the persons involved. He spotted that individual who was at the time departing the medical wing of the hospital. He was wearing a biker cut vest and matched the profile and description of some of the subjects that were involved at the incident at the quarry. Gatsby attempted to detain that subject in order to confirm whether or not he was the person that they were looking for.
Hold on.
Everything okay back there?
Yeah, we're fine.
Okay.
Continue, Your Honor.
You can proceed.
Okay. So as I was saying, Gatsby did detain that subject, or attempted to do so, to verify whether or not he was one of the people that the sheriff's office was currently looking for. Gatsby gave him lawful orders to stop. The subject did not comply with those orders. He was given multiple orders. I'm sorry, am I being cross-examined or?
Not yet.
No,
Proceed,
you're fine.
Sheriff.
You're fine.
Are you able to lower your voice, Mr. Davis? Just a little bit?
Sorry, Your Honor.
All right, perfect. All right, you can proceed.
We're ready.
So anyway, Major Gatsby gave the suspect multiple lawful orders to stop, which the suspect did not comply with. He then made an effort to flee from Major Gatsby, continuing to walk out of the hospital and saying no after Gatsby had already ordered him to stop.
One moment, Sheriff.
Okay.
Just for clarification for the court, the subject, is it fair to say that the subject relating to this case is Junior Bucks as a part of the plaintiff team?
Yes, I can confirm that.
Do you see Junior Bucks here in the courtroom today?
I do.
Can you point him out to the court, please?
Yes, right there, wearing the black suit, white shirt, and black tie, standing next to his counsel.
And would it be fair to say that anytime you reference the word subject, you are indeed referring to the plaintiff in this matter, Junior Bucks?
Correct.
Okay, continue, Sheriff.
So after making multiple attempts to lawfully order the suspect to stop, the suspect didn't comply, told Gatsby no, and attempted to flee from Gatsby. Based on my expert opinion, it is reasonable to believe that based on the behavior of that suspect at the hospital, that this was indeed one of the individuals associated with the shootouts at the quarry, again, based on the facts that were available to us at the time. And with that being said, it would make an escape from police custody a crime. And obviously, if you look at the letter of the law and what it says about evading arrest, it constitutes anything from fleeing a police officer on foot, fleeing a police officer in a vehicle, basically evading police anytime they are bringing you into custody for what is a lawful reason, which at that point, in my legal opinion, Gatsby did have legal authority to detain that subject and investigate whether or not he was involved in the incident that took place earlier. Once Major Gatsby deployed his taser to gain control of the subject, he did investigate and, of course, correlated with the other law enforcement that had responded to the scene. And Gatsby was able to determine that the subject was not involved in the incident and was not the person that they were looking for. Gatsby ultimately released that subject. I believe, in my experience, that it could definitely be argued that Gatsby could have taken the route or chosen to charge that person with evading arrest, since at the time that Gatsby detained him, he was giving him lawful orders, which the subject refused to follow. But Gatsby, using what I consider to be good judgment and officer discretion, chose not to charge him with anything and instead released him. And of course, and as a result of that, the subject was able to walk away potentially unscathed. I mean, other than the minor medical treatment that has to happen anytime taser prongs make contact with anybody's skin. My position as the sheriff is that the actions taken by Major Gatsby were justified and reasonable based off the facts and circumstances regarding the incident. I believe that his actions are further justified based on U.S. Supreme Court case law, as well as qualified immunity. I also take the position that qualified immunity, although it's valid, doesn't really have any necessity in this matter due to the fact that, based on my expert opinion, none of the subject's constitutional rights were violated at any time during the encounter.
Okay, Sheriff. Based on the evidence provided by the plaintiff's team, and you stated that you have had an opportunity to review this matter, based on the evidence provided and to take into account the Graham versus Connor standard, if you were in a similar situation, do you find it necessary and reasonable to have detained this subject with the facts and circumstances that Major Gatsby had at the time? Do you believe that was reasonable and necessary to detain him?
I do.
Can you tell us why you believe that's reasonable and necessary?
Yes. So simply due to the fact that the incident that we had responded to that started this whole ordeal was a very violent shooting with multiple victims. So it can be reasonably stated that based on the facts available at the time, that the person that Gatsby was trying to take into detainment was not only armed, but also potentially dangerous. So, not only is it reasonable, but I feel like it's our requirement with the oath that we take as law enforcement officers in order to detain that subject and investigate to make sure that he either is or is not who we're looking for. Because on the off chance that he is who we're looking for, we can't sit idly by and let him harm somebody else. It's our duty. It's our duty to take him into custody in the most reasonable way that we possibly can until we verify that no crime has been committed by that individual.
And Sheriff, based on the evidence provided by the plaintiff's team, if you were also in a similar situation based on your experience as a law enforcement officer, do you find it reasonable and necessary to use a taser based on the facts regarding this circumstance that Major Gatsby was presented with?
I think that not only using a taser was reasonable, but actually showed a great deal of restraint. The reason I say that, yes, so the reason I say that is Graham versus Connor, while it does directly cover every type of use of force on the use of force continuum, in most cases, when Graham versus Connor is brought up, it has to do with lethal force. The thing is here is that based on what we knew at the time, the facts available to us, it's reasonable to at least suspect that that individual was, again, armed and also possibly involved in what is a violent shooting. At that point, based on the facts that we have, we could reasonably consider that person a violent fleeing felon. And with that in mind, Graham versus Connor, I would argue, would have covered Gatsby even if he had chosen to use full-on lethal force against this individual, as well as Tennessee versus Garner. So the fact that Gatsby not only did not use lethal force in the matter, but was able to take this person into custody without incident using a less than lethal force option is testament to his good judgment and history of de-escalation and efficiency in his police work. I mean, in my opinion, he took into custody this person in the least abrasive way possible, considering the circumstances.
And Sheriff, since you referenced it, I have to ask, can you explain Tennessee versus Garner to the court, what that is?
Yes. So Tennessee versus Garner, in summary, states that if the police can articulate that a felon that is fleeing from their custody presents a imminent threat of either serious injury or death to the police or the general public, then lethal force is authorized to be used against that person, whether they are presenting lethal force at the time against police or not.
And is it your belief that, based on the facts and circumstances that Major Gatsby had presented to him at the time, that Mr. Bucks, being a potential subject who was already in custody, being transported by local EMS, having been involved in the crime of the shootout at the quarry, could have been, if Major Gatsby had chose to pursue a more intense use of force option, he would have been essentially governed under the case law of Tennessee versus Garner. Is that your expert opinion?
Yes, it is.
Okay. Just some final questions here. How long have you known Major Jason Gatsby?
7 years.
And in that 7 years since you have known him, can you basically explain how he came about in the Los Santos County Sheriff's Office or before? Can you basically explain your involvement with him over the past 7 years?
Yes, I've known Gatsby since the very beginning of his law enforcement journey. I was involved in his training process. He went through my academy. If I could recollect correctly, I actually am the one that personally signed off on his completion of my academy. Since then, Gatsby is, in my opinion, an exemplary officer, and that is why he has worked his way all the way up through my ranks and is now a trusted and valued member of my command staff. This agency would not operate the same without him. It would be a lesser agency as a result if he were ever to be put in a position where he would have to leave it. He was also in 2019 presented with the Los Santos Police Department Medal of Valor. At that time, I was the chief of police in Los Santos. Gatsby was a member of command staff at that point too. And his actions that day that he was rewarded the medal not only resulted in multiple violent criminals being taken off the streets, but he also saved the lives of myself as well as many other officers that were involved in that particular scene. Gatsby has a impeccable record. I've never had a situation where I have seen him violate anybody's constitutional rights. I've never had a situation where he's made a false arrest. I've never had a situation where he's used excessive force. He is, by all accounts, a model officer, in my expert opinion.
And in your expert opinion, do you believe that Major Gatsby's actions on the night of New Year's Eve were reasonable and necessary based off the circumstances that he was presented with at the time?
Yes, I do.
No further questions, Your Honor. This concludes our direct examination.
All right, thank you, Mr. Mason. Counsel, for Mr. Bucks, do you wish to cross-examine this witness?
Yes, we do.
All right, Mr. Davis, Mr. St. Patrick, which one of you?
It'll be Your Honor, St. Patrick's.
All right, Mr. St. Patrick, you can come forward.
Hello, how are you doing today? Is it Mr. Oakley?
I'm doing well today, sir. How are you?
All right, doing pretty good. I just got a few questions for you. I won't take too much of your time. But could you tell me and tell the court what is your standard practice when trying to detain or stop anyone that you believe is a suspect?
So our standard practices in regards to that matter actually come directly from what the U.S. Supreme Court sets forth, what is federally required of police officers when it comes to not only detaining someone or taking someone into custody, but any use of force that relates to that.
No. We're not talking about use of force. What would you say, Mr. Oakley? What would you say to someone that you have questions to, that you suspect have been involved in a crime of some sort, or you're trying to get more information? Even if you were to go and you want to ask a witness or someone you think is a witness in any case, how would you go about doing that? How would you introduce yourself?
Not sure if I fully understand the question. I believe that you might be referring to what is called the Miranda warning, which stems from the Supreme Court case law Miranda versus Arizona, which is you have the right to remain silent. Anything you say in court can and will be used against you clause. Is that, am I understanding that correctly?
No, no, sir. Here's what I mean. If I were, let's just say, a police officer, and I was conducting a traffic stop, I would walk up to the vehicle in which I have stopped, and I would state, "Hello, my name is Rollo St. Patrick's. I am a sergeant of this department. The reason why I'm pulling you over, that's what I'm saying." So let's go back over it one more time. How would you have approached my client, Mr. Bucks, in that situation that took place on New Year's Eve at the hospital?
I would have given him direct and concise lawful orders to stop.
Without
then-
without identifying yourself.
I wouldn't have to identify myself. The reason being is that the first step or the first tier in the use of force continuum is officer presence. Major
Officer
Gatsby was
presence.
wearing a clearly marked sheriff deputy uniform when he made contact with the subject. So no, identifying himself with verbal indicators would not have been required at that point.
Awesome, guys. So you guys do not have to identify yourself verbally. Am I understanding this correctly?
That is correct, and that has never been a requirement in a situation like that for any agency that I have ever worked for in my experience.
Okay, so you're saying that me myself, I could go I can buy this police uniform, and I can just. Have you ever heard of people being imitators, Mr. Oakley?
Yes.
Yes. Do you have you ever known any cases to where people have imitated police officers in at any time in your career? Has there ever been any situations to where you have known of people to imitate police officers?
I have seen 2 instances of that in my career.
Thank you, Mr. Oakley. And with that being said, Mr. Oakley, could it be that my client, Mr. Bucks, could have had did not know who this officer was that was trying to, or this person was that was trying to stop him in the hospital? Could that be possible?
In this scenario, no, because I specifically remember in the body cam footage that I viewed the subject saying, "I don't talk to cops," and that was before Major Gatsby even deployed his taser. So that would lead a reasonable person to believe that that person did know that he was dealing with police.
Could it be that my client, Mr. Bucks, was just stating that because that's his right to state that, whether that was a legitimate officer or someone that
Objection, Your
was
Honor.
dressed in a
Hearsay.
costume?
Sustained.
So again, could that be the case that my client, whether it had been a real cop?
Your Honor,
Yes, Mr. Mason.
I would like to I would like to pause for a 5-minute recess. The sheriff was flown out of the city for a timer. If you can give us 5 minutes to have the sheriff flown back in, please.
Yes. We can take a brief recess. Right. Sheriff Oakley, are you all right?
I'm good. My apologies. My brain exploded.
No, you're fine. You're fine. I understand that it happens from time to time. All right. Are we ready to continue?
Yes, ma'am, we are.
All
The
right.
defense is ready.
All right. You may proceed.
Welcome back, Mr. Oakley. Nice to have you back with us.
Thank you.
So continuing on with the questions that I have for you here, would it be safe to say that my client, Mr. Bucks, could have been confused in the moment, being that there are people out there, when you say, Mr. Oakley, that do impersonate or try to imitate police officers or anyone that they can. just to have a thrill or just to try to get over. Would that be safe to say, Mr. Oakley?
Well, I feel like any answer that I provide here is going to be purely speculative, but
Well,
my
answer it to
my-
the best of your ability.
based on my opinion from a law enforcement perspective, no. The reason I say that is because while I acknowledge the fact that police impersonation does happen and it does exist, it's such a rare occurrence that it's really hard to at least with any sort of facts argue that somebody would be confused. I mean, especially when it's very well known that the sheriff's office, we all wear a consistent color scheme. We have a uniform standard operating procedure for this very reason. We all wear consistent uniforms. We all wear badges. A lot of times we wear a uniform carrier that says sheriff really big across the back. We drive marked vehicles. We take every effort that we can to make sure that when we interact with the public, that it's very obvious to them who they're dealing with and what agency we belong to.
Got you, and I do respect you for your answer. But when stating facts, okay, we're gonna remain factual through this whole thing. There is a chance, though, that someone could imitate a police officer.
Your Honor, I'm going to make an objection as to both relevance and hearsay. The plaintiff in this matter is arguing about facts, but there has been nothing submitted in evidence which states that it's a fact that the plaintiff believes that Major Gatsby was impersonating law enforcement.
Your Honor, if I could, I would like to respond to that. I'm stating this question is to Mr. Oakley on if it is possible, not directly linked to this case, but if it is at all possible that someone can impersonate themselves as being a police officer.
And
It's a
Your
simple
Honor,
question.
I'm going to object again to asked and answered.
Sustained.
Thank you.
No, Mr. Davis, or Mr. St. Patrick, that means don't. I don't think that you should be answering that question anymore.
No, I was saying thank you. I just moved forward.
Oh, okay.
Yes. Okay, Mr. Oakley.
Let us say
you
thank you.
stated
Continues.
that you had the privilege of reviewing body cam footage. Is that correct?
That is correct.
And viewing that body cam footage, did you at all see or hear that my client, Mr. Bucks, was being detained or said that he was detained?
I will need you to rephrase the question. I don't understand what you're asking me.
Okay. Did Mr. Gatsby, in the footage that you saw, tell my client, Mr. Bucks, that he was being detained?
If I recollect correctly, yes. Because, and the reason I say that is because at no time was your client ever placed under arrest with the understanding that there's a clear difference between somebody being detained and then fully being placed under arrest.
Okay. Totally agree with you on that. Did you see in the video when Mr. Gatsby told my client, Mr. Bucks, that he was being detained?
Are you asking me if I heard in the video Gatsby say those exact words? Is that what you're asking me?
Did you hear it?
I'm going to be honest, I don't recall. I watched the video yesterday, but that's a very specific detail, and I can't answer yes or no to that. I don't remember.
Okay. Well, I can tell you that in the video, Mr. Gatsby, after my client was tased in the hospital, cuffs put on him, is when Mr. Gatsby told my client, Mr. Buck, that he was being detained. A couple more questions for you, here, Mr. Gatsby. You seem like a very intelligent guy, and
Objection. Misidentification of the witness.
What would you
He's speaking with Sheriff Oakley, not Major Gatsby.
correct that for the record, Mr. St. Patrick.
Mr. Oakley,
Yes.
when reviewing the said body cam footage of Mr. Gatsby, did you at all think that the force that was used on my client, Mr. Bucks, was excessive?
Objection. Asked and answered. It was
Overruled.
asked. Thank you, Your Honor.
Mr. Oakley, is it proper practice for your department to refer to individuals that you may stop by skinhead?
No, it is not.
Okay. Would you say, Mr. Oakley, that was a little over the top?
Yes, and I actually have already proactively reprimanded Major Gatsby for that, and he served an administrative suspension for it. We talked about it in great detail.
Yeah, so over the top that my client back there, Mr. Bucks, received a hair transplant because of the words that were spoken to him on that day.
I'm sorry to hear that. As I mentioned, I did reprimand Gatsby for that, but unless there's something that I'm not aware of or some law that I'm not aware of, while him calling him that was what I would consider to be unprofessional, I don't believe that it violates any laws.
So with the number of years that you have known Mr. Gatsby and all of the wonderful things that
Sorry
you
for
have
laughing.
named on his resume, it is a slight chance that Mr. Gatsby could be unprofessional at times. Would that be accurate to say?
Well, I mean, I guess it depends on how you frame it. I can tell you that this is the only time that I've ever had to place Gatsby on administrative leave in this entire 7 years that he's worked for me. And it's one scuff on an otherwise spotless record. But regardless, as I said, I did take proactive measures to make sure that it was addressed without being prompted by any sort of outside influence. We took care of it in house as soon as I was made aware that it happened. We took care of it right then and there.
Got you. And
That's okay, Windman.
that's well appreciated that you took care of that. Also, I have just a few more, and I'll get out of your hair here. Is it your rightful duty, Mr. Oakley, to identify yourself when trying to apprehend a suspect?
Objection, Your Honor. Asked and answered.
Sustained.
When reviewing the body cam footage, Mr. Oakley, you stated that my client, Mr. Bucks, was released from custody. Is that right?
That is correct.
At no point in time did my client, Mr. Buck, ask, did he need any treatment, medical treatment, or anything like that? Would you agree?
Yes, that's correct.
Because of that, my client, Mr. Buck, is suffering from back problems as well, Mr. Oakley. I'm not sure if you're aware of that, in which he took a pretty hard fall. I'm glad it wasn't too much of a head injury. I think he was.
Objection, Your Honor. I'm going to object to the relevance. There's been no medical records submitted as evidence in this case, and I'm going to lay my basis on the objection based on that.
I will sustain that.
All right. Last thing, Mr. Oakley. as far as Mr. Gaspy goes, is concerned in this matter, reviewing the body cam footage, Mr. Gaspy sort of kind of, I guess you could say, sped the process up faster than it should have been. It could have been de-escalated, is what I'm saying.
Objection
Versus
to the
going
form of
straight
the
to a state.
question, Your Honor.
I'm sorry, say that again, Mr. Mason.
I'm gonna object as to the form of the question. I believe it was compound. I believe he asked multiple questions, which could potentially confuse Sheriff Oakley. I would ask that the plaintiff.
I can
restate
shorten
his
it up for
question.
you.
Thank you.
Yeah,
thank
I
you.
can shorten it up for you. Mr. Oakley. Mr. Gaspy could have de-escalated the situation.
Are you asking if I think that he could have, or if I think that he could not have?
Do you think that Mr. Gaspy could have de-escalated the situation that took place on New Year's Eve?
I'm not sure I understand which part of it you're asking about, but in my expert opinion, no. Because as I stated before in my testimonial in regards to what the person was suspected of, as well as the case law that I brought up, us getting him into custody before we could verify his involvement was a life and death situation based on the facts that we had in front of us at the time. So at that point, and pardon my frankness, but de-escalation be damned. We need to do what we need to do to get him into custody to make sure that he does not provide any sort of threat to the public. So no, I think that other than the one thing that I've already reprimanded Gatsby for, his actions were completely reasonable, and I would have done exactly the same.
Okay, got you. Let me ask you this: is there proper practice without knowing the exact identification of a person or a persons of interest to just walk around, tell them to stop, and tase them? Is that proper practice without identifying yourself?
No, but I already established in my testimony and by watching the body cam that Gatsby had more than enough reasonable suspicion to believe that the person that he was detaining was involved. But no, it's not common practice for us to walk up to random people that we don't suspect of anything and give them a bunch of orders. But Gatsby had reasonable suspicion to believe that this person was involved in a violent crime, and he took action as such.
Is it true that my client, Mr. Buck, was set free after knowing that he wasn't who Mr. Gatsby was looking for?
Objection asked and answered, and I would also like to pause. I believe Mr. Davis has disappeared.
Oh.
Unless Mr. St. Patrick is prepared to proceed without him.
No, we're good.
Okay,
Okay.
well then my objection stands, asked and answered.
Do you have anything to say to that, Mr. St. Patrick?
No, we can move along.
Okay, sustained.
Yeah, we can move along. Mr. Oakley,
Mass people
you
come in here.
stated that you've been in law enforcement for some years now.
That's correct.
Do you believe that there could be how can I word this? You mentioned something about cuts or a vest on.
Correct.
Were you informed on what type of vest or type of cut, as you would say, that your officers were looking for on that day? Did they give you any kind of description of the vest or said cut that was the persons of interest was wearing that day?
I'm just testifying based on the evidence that I've reviewed, but based on that evidence, I would argue relevance on the type of cut. And the reason I say that is because identifying information when police are looking for somebody. We give out enough information to make sure that we can clearly identify the person that we're looking for. So it's along the same lines of like saying that we're looking for somebody that has black hair and wearing a black shirt, but
Okay.
you'd be arguing the difference between like a black t-shirt and a black polo. It's still a black shirt.
Gotcha.
I'm not sure if that gives you the information that you're looking for, but
No, it does. It does.
that's just standard practice that we give the best and most accurate description that we can with the time that we've got.
Got you. And that totally answers the question, which brings me to my next question. When observing a person who has on a vest or a cut, you would agree that, or would you agree that there's different things that are placed on those vests and cuts? There's different wording and there's different symbols and there's different things, right?
Your Honor, may we approach?
Yes.
I'm whispering here, Judge. Can you hear me?
Yes, I can.
So the sheriff has already testified that he wasn't there personally. His testimony is based off of the review of the evidence that he had at the time. I believe this goes into asked and answered. He's already testified based off of what Major Gatsby was presented with, which was the biker who was wearing the cut, who was involved with one of the shootouts occurring at the quarry. I think Mr. St. Patrick is trying to lead the sheriff down a road where he's trying to testify to evidence that he wasn't directly involved in, which is outside of the evidence that's been presented by the plaintiff, which is the body cam footage.
I would venture to say that I'm not, due to the fact that Mr. Gatsby waived his rights to get up here on the stand. So I'm trying to get
An individual can't be held against that.
right. He's not been held against it, but I have to get a picture of what said officers see on a daily and what they go through. I have to get that for my client because it's relevant to the case, because there are different things that are placed on those vests. There's different things that are placed, and if there was the slightest of miscommunication with the officers, or with what my client was wearing versus what someone else was wearing on a vest or a cut, that needs to be heard here in the court.
So, Your Honor, just to follow up on that, the sheriff once again can only testify based off of the evidence that he has reviewed, which is the testimony of Major Gatsby and the video evidence that was presented in this courtroom setting. Your Honor, I dare to say that the sheriff did implicate me as the chief deputy, who is the one that ordered Major Gatsby to follow that ambulance. So if Mr. St. Patrick wants to go down the path of potentially questioning me, that certainly opens the door. But I would argue that Mr. St. Patrick should limit his questioning based on the testimony and the belief that the sheriff has based on the evidence that he reviewed, and not speculate on what may or may not have been told to Major Gatsby in that moment.
Not told to Mr. Gatt. This is me talking to Mr. Oakley. Not when the questions about the cuts have nothing to do with Mr. Gatsby and what Mr. Gatsby told him. This is from me getting a perspective from a tenured officer on standard procedures when out in the field.
Yeah, I would just follow up with asked and answered, Your Honor. I'm going to leave it up to the court on how you want to proceed with it.
Honestly, hearing from the both of you, I do agree with what you said, Mr. Mason. However, I do think for what Mr. St. Patrick was saying, I think just for the opportunity for others to probably listen again, I think for this moment, I think it'd be fine for him to ask his questions.
Okay.
Which
I'm more than happy to move on with it.
which I mean, how many more questions do you have that pertains to this subject?
That was literally the last question.
That was the last question. Okay. Well,
Yes.
you can ask your last question again, and the sheriff can answer that.
Will we, I'm assuming we'll have redirect, Your Honor?
Yes.
Okay, thank you. I got nothing further.
Okay. Thank you.
Thank you.
You may proceed.
Thank you, Your Honor. Who wants to
So
speak? Mr. Oakley, Could
Yes.
you continue on with your statement to the question that I asked? Could it be, is it true that um, these vests or cuts have different symbols, different wording, different, I guess you could say, pictures on them, if you will?
I'm sorry, I just need a second. I'm trying to make sure I understand the question correctly.
Okay,
But
I'll do it one more time. Is it true that when one is wearing a vest or a cut, that there's different symbols on those cuts and different things on the front and the back of those cuts?
yeah, all the MCs that I've dealt with have a black cut, and then they have different like accent colors and text and stuff like that. But at the base level, they're all black. Based on what I do recall from the body cam evidence, though, the suspect was, as I mentioned before, described as a biker wearing a cut. There were only 2 people in the hospital at that time, and only one of them was wearing a biker cut. So again, that just it further goes into what I explained earlier about Gatsby having reasonable suspicion that was the person that they were looking for.
Thank you. I appreciate your time. Thank you, Your Honor.
Thank you, Mr. St. Patrick. Mr. Mason, do you have further questions for the sheriff?
I do. I have some redirect, Your Honor.
Okay, you may step forward.
Your Honor, would you like me to give a moment for the plaintiff?
Are you two good over there in the corner?
No, yeah, we're good.
Or 3 of you, excuse me. All right, you're good? All right.
One moment, Your Honor.
Okay.
Apologies, I'm just trying to make sure my brain doesn't explode
Oh,
again.
I do the same thing. Gotta stretch your legs, uh,
All right, Sheriff, are you with me?
I am.
Okay. As we've already established, you've had an opportunity to review the body cam footage. Would the words "hold on there, partner" give someone a reasonably belief that they should stop?
Yes, I believe it implies it.
Okay. And members of the Los Santos County Sheriff's Office, they wear a full uniform, right? With a badge and Sheriff's Office insignia and everything?
Objection, Your Honor. That was asked and answered already.
Sustained.
Sheriff, was this a traffic stop?
It was not.
And would you argue that this was a consensual encounter or a reasonable suspicion encounter?
This was a reasonable suspicion encounter.
And in reasonable suspicion encounters, members don't have the right to just simply walk away from a police officer who's told them to hold on their partner, or in essence to stop.
Correct. They are lawfully seized until the conclusion of the investigation.
In the body cam footage, did Major Gatsby identify himself as he was Major Gatsby with the Los Santos County Sheriff's Office? And furthermore, did Major Gatsby provide the plaintiff with his badge number on multiple occasions?
Objection, Your Honor. That was already asked and answered.
Your Honor, that specifically, to my knowledge, was not asked and answered.
Overruled.
Sheriff, was it in the body cam footage, did Major Gatsby identify himself and provide his badge number on multiple occasions to the plaintiff?
Yes, after he tased the individual and took him into custody, Major Gatsby identified himself with his name as well as his badge number. And if I recall correctly, he was standing in full uniform next to a marked Los Santos County Sheriff's Office cruiser.
And even before that, it's reasonable to assume that a prudent person would identify somebody as a police officer based on the uniform that Gatsby was wearing, plus the badge, plus the verbal order to hold on their partner, or in essence,
again,
stop.
Your Honor, that was already asked and answered.
Sustained.
Sheriff, since the body cam footage was presented on behalf of the plaintiff in its entirety. Did you state, just to recollect my memory, did you state that Major Gatsby cut the plaintiff a break as far as additional charges could have been provided on him, namely going over 100 miles an hour in the city on a bicycle, which could be argued as reckless driving, plus the multiple commands to stop provided by Major Gatsby?
Objection, Your Honor. Objection, relevance.
Your Honor, this is all from the body cam footage that was presented on behalf of the plaintiff, so it opens the door for me to talk about it because it's already been admitted as evidence.
I will overrule that.
So with the plaintiff driving over 100 miles an hour in the city, reckless driving, potentially placing countless innocents in danger, not even that included, but based off the conduct the plaintiff presented to himself in the hospital, do you believe that Major Gatsby was being generous by not charging the plaintiff with further crimes?
Yes, based on my knowledge, it would have been possible to charge the suspect with evading arrest, criminal speed, which would have resulted in a revocation of his driver's license and his vehicle being seized, as well as reckless endangerment.
Sure, and Major Gatsby didn't do that, right? He was cutting him a break.
That's correct.
Right. And would you say that, you know, it's fair to say that you get what you get in terms of interaction quality in this state?
Yes. Based on my experience, a large group of civilians that we've dealt with, they're very quickly to tell us in sometimes not respectful ways when they don't appreciate what we're doing.
Right. And to quote, "I don't talk to cops," was uttered by the plaintiff. And in this instance, it wasn't a matter of where he had the right to walk away. He was detained based on Major Gatsby's knowledge that the plaintiff was already in police custody from the court. Is that correct? So the plaintiff didn't have an option to walk away. Correct.
No, he was lawfully seized at the time.
Okay. And just to recap, officers aren't judged in 2020 hindsight, correct? With Graham versus Connor, they're judged based on the facts that they're presented with at the moment in time, based on the beliefs of a reasonable, prudent another officer. Is that correct?
That is correct. And the text case from the case law says that basically verbatim.
And I'm going to strike. No further questions on redirect, Your Honor.
All right. Thank you, Mr. Mason. Mr. Davis, Mr. St. Patrick, do you have any further questions for the sheriff?
I do. I have two.
Okay.
Thank you. Hello again, Mr. Oakley.
Hello.
Just a couple of quick questions. What is your definition of detain?
Okay, so a reasonable suspicion detainment means that there are several factors that contribute to give an officer reasonable suspicion in order to lawfully restrain that person until they are able to fully investigate, collect evidence, and either verify that a crime has been committed or that the person that is being detained has not committed a crime, which of course would therefore result in them being released.
Thank you, Mr. Oakley. The next question that I have, Mr. Oakley, you get what you get. Is that professional and proper protocol that you guys go by?
If I understand the question correctly, what I have in my policy is that we need to make sure that we as police officers are being reasonable when we are deciding what sort of punishments to hand out. In other words, we base everything that we do off of what the federal government, the U.S. Supreme Court, has established as either lawful or unlawful for police officers. But, and just like with many other things in life, if someone seems to be more willing to cooperate with you, or, you know, as opposed to being argumentative or combative, then, you know, obviously we're going to be more inclined to, you know, try to work with those people, cut them breaks, that sort of thing. So it's, and, you know, this happens within the state of San Andreas as well as everywhere else in the United States. I mean, if you get pulled over by a police officer and you're going 5 miles over the speed limit and you're really nice and you're respectful and you apologize, then your chances of walking away with a warning are a lot higher than if you cause a scene or start yelling and screaming, or, you know, if you're just generally disrespectful, you know, because there's what's called officer discretion.
Got you. And I don't want to talk to the cops as disrespectful in your eyes.
Well, I mean, I guess you're just asking for my opinion more so than me, you know, to state a fact, but
I'm asking.
I would
you.
argue that, well, it would depend on the scenario for me, but I would chalk that up to, again, officer discretion. I mean, you know, you could say something to me that I might find to be disrespectful, but the judge over here may not agree with that statement, or vice versa. So, you know, officer discretion, there is some human opinion that's involved in that. But
And one last question.
okay,
Hold it there, partner. That's proper protocol for your department to stop and detain someone. Yes or no?
no, but I mean, I don't know of any department that has like a list of phrases that you're allowed to use when you're trying to get somebody to stop. There's not like standard or anything on that set forth by the government. I mean, there's, you know, that would be like, you know, for instance, if if I walk up to you and say, "Hello, I'm Sheriff Oakley with the Los Santos County Sheriff's Office," but I'm supposed to say hi to you instead of hello. You know, there's certain things that we are dictated to say a certain way. For instance, like the Miranda warning from Miranda versus Arizona. But there's some things that, you know, because of the fact that this job is very reactionary, we have to make a lot of split-second decisions in the moment. We can't dictate exactly how everything is worded 24 hours a day with every interaction that we have. It wouldn't be possible to do it.
I'm not saying it's possible. Your answer was no, right?
Yeah, no, there's
Okay.
I don't have stop their partner listed in my standard operating procedures. No, I don't.
Okay, so no. Thank you. No further questions, Your Honor.
All right, thank you, Mr. St. Patrick. All right. Any further questions for the sheriff?
Just briefly, Sheriff, you said you give your officers discretion based on how they handle calls, provided they don't violate any constitutional amendments or rights of citizens.
That's correct.
And there's no script that dictates what an officer has to say when they basically inform somebody that they're detained, right?
No.
No further questions, Your Honor.
All right. Well, is that all the questions from both sides?
That's all the questions I have, Your Honor.
That's it.
Oh, all right.
Aside from closing arguments.
All right. Mr. Mason, do you have any further witnesses that you'd like to call to the stand?
Major Gatsby has invoked his Fifth Amendment privilege to remain silent, and Sheriff Garrett Oakley was the only witness I intended to call for, so the defense rests as far as witnesses goes.
Okay, thank you. Sheriff, you may take a seat. Thank you.
Thank you.
All right. Now we can move on to the closing arguments. Plaintiff, Mr. Davis or Mr. St. Patrick, one of you have closing arguments?
Yes, Your Honor.
All right.
Your Honor, it seems to me that, and it should be to the courts as well, that my client, Mr. Buck's rights were severely violated. Not only was he not properly stopped and detained by law enforcement failed to identify themselves as law enforcement. Hold up, buddy, is not a way to identify yourself and suspect that somebody is supposed to stop because you have on said uniform. Furthermore, Your Honor, my client was tased. He fell and hurt his back, Your Honor. He was called a skinhead, Your Honor, which caused my client to go and have to get plastic surgery, and he has hair on his head now. Your Honor.
Your Honor, I've already objected to that. As far as the medical records go, it's not been presented as evidence. And I believe the court's already ruled on that.
You may continue, Mr. St. Patrick.
Thank you. It's clear that my client's rights were violated. His First Amendment right was violated. Your Honor, if he doesn't want to talk to police officers, he doesn't have to talk to police officers if he doesn't want to. And just because he
Your Honor,
doesn't
that's
want to
a
talk,
misstatement of the law.
I believe you're thinking of the Fifth Amendment, Mr. St. Patrick.
yes, the fifth, sorry. If he doesn't want to talk to police officers, he doesn't have to. Okay, that's his right.
Mm-hmm.
And a police officer should identify themselves properly when trying to detain someone, especially if they're as hostile of suspects that they were looking for. Turns out that my client, Mr. Bucks, wasn't even the guy. Not only that, when they let Mr. Bucks go, they didn't even offer him any medical treatment. None of that. Very unprofessional, Your Honor.
Mm-hmm.
My client has suffered for this. My client would not be able to get that New Year's Eve day back. That's how his New Year's was spent, Your Honor. Didn't get a chance to celebrate. Didn't get a chance to have a good time. He spent it frustrated and wondered why he was treated in such a way as he was treated. The force, Your Honor, that my client was treated with was unnecessary and uncalled for. Regardless of what one thinks, you should be professional enough to identify yourself properly.
Why are you sad, Windman?
So that people like my client have their rights not violated, but they have the option to decide whether they want to stick around and talk to you or not. Furthermore, Your Honor, if he had told my client that he was detained, I'm pretty sure my client would have stopped right then and there. But no, he only told my client that he was detained after he had already tased him and after he had put cuffs on him at the 2:45 mark on that video.
It's almost over.
My client, Mr. Burks, is a good guy, wasn't causing any problems, just didn't want to talk to police officers, and this is what he gets, Your Honor. Thank you.
Thank you, Mr. St. Patrick. Mr. Mason, your closing argument?
Thank you, Your Honor. I would just like to recap some of the things that we heard from Sheriff Oakley. As we know, and as the court heard, several minutes before the incident at the hospital even occurred, we had a shooting at the quarry in Sandy Shores, which involved multiple individuals, a lot of which were bikers. There was a lot of multiple subjects who were already in police custody, who had been injured and were downed, and as a result, had to be transported to the hospital by local ambulance, as the on-duty EMS did not have the capacity to transport all of those downed individuals solo. We heard the sheriff testify to that. As the court knows, Major Gatsby was ordered to follow a local ambulance to the hospital, which contained one of the individual subjects who was involved in the shooting, wearing a biker's cut, who was already in custody, to the hospital. Your Honor, we know that Major Gatsby followed that ambulance to the hospital. When the ambulance got to the hospital, we heard the sheriff testify that the ambulance and the subject disappeared as it arrived at the hospital, which is normal in the state. Major Gatsby then had to park his vehicle, walk inside the hospital to attempt to find the subject who was involved with the shooting at the quarry, who was wearing the biker's cut. Gatsby spotted two individuals, as the sheriff stated, one of which was wearing the biker's cut. That individual matched the profile of the information that was provided to Major Gatsby, as the sheriff testified to, Your Honor. Major Gatsby then attempted to detain the subject in order to identify if he was the subject that was involved at the quarry or not, based on the good faith belief of the information that he had at the time. We've heard from the sheriff that Terry versus Ohio allows an officer to detain a subject based on reasonable suspicion that criminal activity is afoot. That we know that the subject failed to comply multiple times when Major Gatsby told him to stop, hold on there, partner. We know that there's no script which an officer has to provide in order to inform somebody that they're detained. And furthermore, there's no law that requires an officer to advise somebody that they're detained before the handcuffs go on. That's an officer safety issue. And the Supreme Court is very clear on that, Your Honor. We know that the subject said no multiple times to Major Gatsby after the Major ordered him to stop. It's reasonable to believe that based on the behavior of the subject at the hospital, that he was indeed one of the individuals who was associated with the shootout at the quarry, and thus would make him an escapee from police custody. And furthermore, he was evading the police in that moment by failing to stop after Major Gatsby told him to. A result of which the Major used his taser based on the good faith belief that he had at the time that the subject was indeed somebody involved at the quarry and who was actively evading arrest, which I would argue he was already arrested. So we had a fleeing felon at this point. The sheriff testified to all of this. And after it was confirmed that the subject that Major Gatsby had in custody was not the same subject from the quarry, he was ultimately released. He was let go. He could have been charged with a plethora of other crimes, like I stated earlier, over 100 miles an hour in the city, reckless abandon, reckless driving. Mr. St. Patrick wants to say that the plaintiff wasn't enjoying his New Year's or wasn't getting his New Year's back. He was enjoying his New Year's. This is a guy who was driving over 100 miles an hour in the city on New Year's Eve, living it up, partying it up. And Mr. St. Patrick wants to say that his New Year's was ruined. Frankly, I find that hard to believe. Fortunately for the plaintiff, Major Gatsby was kind enough not to pursue the matter further. And we've already heard from the sheriff about the skinhead comment. Major Gatsby has already been disciplined administratively for that. Furthermore, we've stated, and the sheriff has testified, that in the 7 years that he has known Major Gatsby, this is the one single incident that has been a blemish on his record. And he's already paid for that, Your Honor. And furthermore, the skinhead comment, that's not even a fact of the issue at hand. We're talking about a unreasonable detainment, unreasonable force. That is what's being presented to the court, not the skinhead comment. That was handled outside of the court. We've heard that Major Gatsby is a recipient of the Medal of Valor, the highest award that a law enforcement officer can receive in this city. That alone speaks to the character and the testament of the Major standing behind me. This man is a paragon of integrity and standards and discipline as it relates to interactions with the public in this city, and he should be commended as such. It's the sheriff's office's position that the actions taken by Major Gatsby were not only justified, but reasonable based off of the facts and circumstances regarding the incident, and his actions are further justified based on what the U.S. Supreme Court says is lawful. And Your Honor, the court knows that the Supreme Court is the highest authority in this land. They dictate what police officers are allowed to do and what they're not allowed to do. And everything that the sheriff has testified to has been in accordance with Supreme Court rulings. I believe that, as well as the basis for qualified immunity, completely absolves the sheriff's office of any liability as it relates to this case. The plaintiff's rights were not violated. We know that there's broad speculation. There was no violation of the Fourth Amendment. What Major Gatsby did was reasonable based off the training and the case law that backs it up. And I thank the court for their time, and I would ask this court to promptly dismiss this case and absolve the sheriff's office of any liable as it relates to the claim in this matter. Thank you, Your Honor.
Thank you, Mr. Mason. At this time, we will issue a recess. Within this brief recess, I will be taking in all the information that has been provided by both parties. And once a brief recess, I'd say about 10 minutes has come to fruition, I will come back out here, we will reconvene, and I will give you my decision. Does that sound good?
Thank you, Your Honor. Thank you.
All right, let's go to recess, and I'll be back shortly. So, I have considered everything that's been talked about during this case and the evidence that's been presented. There's a couple things that I do want to go over first that I was thinking about during this course of the trial. And a couple of things, the first thing I'm going to start with is, and this can be answered, but I would consider this more of a rhetorical question. When speaking on the fact of Gatsby following the ambulance in this regard, when looking at the video evidence, Mr. Bucks was on a motorcycle going to the hospital, and I didn't see an ambulance at all during that. I don't know if that is because it was a separate time or we're speaking about the same time. It's just got the situation incorrect. Is there any clarification on that, if possible?
Your Honor, it's our understanding that the plaintiff arrived at the hospital based on his body cam just before the ambulance had arrived.
I see.
Major Gatsby was following. So the timing, we're talking about a difference of about 15 seconds between the
I
plaintiff arriving and the ambulance arriving.
I see. Okay, so he was ahead of the ambulance.
Correct.
Okay, that's what I need to figure out. I mean, it's not really too relevant in this, but I was just kind of confused on that since we're talking about an ambulance and I saw a motorcycle. But thank you for clarifying that for me. In the other regard to which also really isn't relevant, is just the skinhead comment. Obviously, it's already been established that Gatsby has already been reprimanded for that, has been disciplined for that sort of thing. And really, if the claim for racial profiling did exist, there was no real evidence of such thing because I don't find it to be the actual reason for Mr. Bucks to be detained or arrested for anything. And the New Year's thing obviously is not relevant to either in this situation. And obviously the medical jargon or the medical explanation that was being spoken of as well, no relevance either because nothing has been presented in that regard either. So those are just a few things I want to go over. Now for the substance of this, which going over the case laws and the Fourth Amendment, and I guess in this case qualified immunity as well. So we've kind of established the definitions for Terry v. Ohio, Graham v. Connor, but just for the sake of people in the gallery or anybody who is not too familiar with these, I'll read them verbatim just so you guys get an understanding as to what it means and exactly why this is being discussed. So, starting with Graham v. Connor, the definition, this was ruled in 1989. If the use of force violates the Fourth Amendment and the U.S. Constitution, then the standards listed in this amendment will be used. The arrest must be reasonably proportionate to the need of force as measured by 1, the severity of the crime, 2, the danger to the officer, and 3, the risk of flight. And for Terry v. Ohio, this was ruled in 1968. It is an officer can briefly detain a person based upon reasonable suspicion of criminal activity long enough to dispel the suspicion or to allow it to rise to the level of probable cause for an arrest. The officer is also permitted to limited frisk search of the person without a warrant. Before the officer can frisk search the subject, he must 1. Only reach inside the clothing after feeling such objects. 2. Have articulable facts that the person could be armed with a weapon. And 3. limit the search to searching the outer garments of the suspect, excuse me, to feel for objects that might be weapons. Now, these two defined verbatim, the arguments that have been made by Mr. Mason, I tend to agree with in regards to these case laws. And in this case as well, with the questions that have been asked by Mr. Mason as well to the sheriff, I think that these case laws were well within the situation, that these were justifiable, that what happened at the hospital was nothing more than an actual standard procedure of an officer doing their due diligence by detaining a person such as Mr. Bucks here. Now, I will say that, in my opinion, I think the language that was used, I'm not talking about the skinhead, that's already been established, but talking more of the way in which that Gatsby was speaking to Mr. Bucks in order for him to stop, to be detained before being tased. In my opinion, I think maybe a better formality would be to announce your name and who you work for, and, to stop. But that is at the discretion of your employer, not for me. But that's just my opinion. I want to bring that out there. Just, I think for the sake of formality, that's just how I feel in this regard. You may feel differently, but I just want to put my 2 cents in that. But that has nothing to do with the relevancy of whether or not what Gatsby did was actually unconstitutional or not. So after saying all this, I think that in this case, I tend to agree with Mr. Mason on many points that he's made throughout this trial. And unfortunately, Mr. Bucks, I am ruling that your case is dismissed on those grounds.
Thank you, Your Honor.
I don't have a gavel, so court is adjourned.
Thank you.
Thank you.
Hey, well done, both of you.
Thank you.
Well done, guys.